I do need to remind you that this continuing education program is intended for practicing attorneys. This program does not offer legal, medical, or psychological advice and does not take the place of consultation with an attorney or other professional with appropriate expertise and experience. The opinions expressed in this program are the personal opinions of the presenters and not necessarily those of their employers, sponsors, clients, or trial guides. All references to the trademarks of third parties are strictly informational and for the purposes of commentary. No sponsorship or endorsement by or affiliation with the trademark owners is claimed or implied by the presenters or trial guides. And now, please allow me to introduce our speakers for today. Matt Powell primarily represents people with catastrophic injuries and wrongful death cases, but he also continues to be involved in smaller litigation cases as co-counsel with young lawyers. He is regularly in trial representing people injured in auto, truck, medical malpractice, defective products, birth injury, negligent security, and other types of cases. He is known for using innovative methods for demonstrating injuries, including those in minor impact cases. Aaron DeShaw is a trial lawyer from Portland, Oregon, who has individually and in cooperation with other law firms obtained settlements and verdicts for his clients in excess of $1 billion. DeShaw is the founder of Trial Guides and co-founder of Settlement Intelligence. He is the author of 3 books and is featured in multiple professional education and videos on the topics of traumatic injuries and insurance. They both have more extensive biographies on our website, but for today, I'm going to go ahead and turn it over to them.
Thank you, Jessica.
Yeah, thank you, Jessica. That's very nice. And I want to say thank you, everybody, for tuning in, and Aaron and Jessica for asking me to talk a little bit about technology and how we can use it to, pick a better jury. And I think, we can win or lose our case right when we get the jury sworn. So if you pick a jury well and you're a little more organized, I think it goes a long way. And if we could share the presentation, and we'll just kind of go through it quickly. And Aaron, do you have questions or comments about jury selection?
No, not really. It's obviously a really important thing. It's sort of make or break in terms of the case, and trial guides. We've focused a lot of our efforts in terms of books and videos on jury selection. I mean, because I view it as being so critical to, the ability to win a case. Yeah. Anyway, and I think that the benefit of technology is really in assisting us to help find better jurors and be able to identify the ones that are leaning in one direction or another. And I'm going to let Matt sort of go into that in more detail, and I'll ask questions along the way.
Great, thanks. And what I think is important is that jury selection is about communication. And if we could pop up the slide deck, we'll kind of just go through it pretty quickly. And so to me, it's about communication on a couple different levels. It's communication level with the lawyer who's talking to the jury. It's communication with your team who are hopefully collecting valuable notes that are going to help you make decisions when it comes time to make your cause or use your peremptory challenges. And it's also communication with you yourself. And you have to feel comfortable, because if you're discombobulated or having problems, it makes it difficult for the jury to feel that you're really focusing on them. Can we go to the next slide? So common problems we deal with. Next slide. A lot of time pressures. Next. Disarray of our notes. Lots of people may be taking notes in different formats, different pads, trying to keep them all organized when you come back together to meet is really complex. Next. Readability of notes. People are handwriting notes and they're in a hurry, or they're trying to write in a really small seating chart, so their handwriting is real small. That causes a problem. Next. When you're presenting, keeping track of who's where, and if there's changes in the middle, that's a little bit of a problem too. And so with technology, we can use things to help us identify the right seat and the right juror. Next. So invariably, you walk into a court and the judge tells you how the panel will be seated, and then the bailiff seats them in a different order. And so suddenly your seating chart's kind of a mess. So those are challenges that we have to deal with. Next. So what happens is with all these problems, you tend to look like you're in a hurry or you're not well prepared, and you have to sort of get past that impression, because what you want to do is be organized, know that your notes are being taken well, and be confident when you present to the jury. Next. Okay, so we have to be great communicators. We want to look well organized. We can't be frustrated digging through papers. We want to flow and go and be nice and smooth. Next. So what we do with technology is you have team collaboration. And so what we're going to look at today is a way that you're going to be using an iPad, and your team all have iPads, and they're taking notes in real time, and they're centralized so that all the notes go into the app, and you'll see that in a little bit. And they're typed well, they're easy to read. And then when you get to cause challenges and peremptory challenges, the computer takes care of organizing that so you know who's really going to be in the jury box and who's in your alternate box. And if the judge or the bailiff changes the seating or moves you to another courtroom, you can create and change seating charts on the fly really quickly and renumber them and have all your jurors in the right spot. All right, next. Oh, accuracy is the key. You know, when it comes time to make your cause challenges, if you're quoting accurately, consistently, the judge is going to say, yep, that's what I recall too, versus I think they said, and I kind of think that. So by having good notes with your team, taking notes and collaborating, it keeps you well organized and prepared to make those cause challenges. Next. Okay, so let's talk about the seating charts. And what we want to do is create seating charts that fit the courtroom. We want to be able to number them well, and we want to be able to make changes on the fly. And if we could switch to my iPad, here we have a courtroom that I just created, and you can set up any way you want. And if you wanted to add a new section, it asks you how many rows and how many seats. I'll just make a real small one. Done. 3. And you can move things around to configure with whatever your courtroom needs are. So you can save the courtroom name later, so you can use it later. It's designed to be really flexible. And then if you needed to number all the sections, you can do that. If you just want to do a few sections, you can do that as well. You can do it by hand. So I'll take this one away. I'm going to delete that section. And so in this example, I have like a gallery where you may have many jurors waiting to be called. And in this case, what we have here is all the jurors seated. And what happens is when you get the jury pieces of paper in the list from a clerk, you can say, okay, this one's juror number 67. The first name is Aaron Deshawn. And let's say he was born in 1965. It picks his generation. He's a white male. You can make it female. The avatar changes. And he is a lawyer. And what happens is when you get the jury seats, you can say, okay, this person has medical knowledge. If you have the ability to look up their party affiliation, you could do so. And what we did is we just added a new juror. And here he is. And if I put him in the wrong seat, I can move him around. All right, let's go back to the slide deck. Okay, so let's go to the next slide. So creating the seating charts is pretty easy. Juror avatars are very important. And you saw that briefly because you can select their age, gender, race. You can put them in whatever seat they want. And then what's also important is when a juror says their name versus how it's typed on paper, you just adjust the phonetic spelling so that when the lawyer's presenting, he's going to read the name the correct way. Right, next slide. All right, so if we could, we'll go back to my screen and I'm going to show you one of the things that we do to set up. And what I found when I'm picking jurors is that I wanted to know information about the juror quickly. And let's use Aaron for example. I have this color wheel, and if for some reason someone thinks he's a bad juror, they can change his color to red. And what that does is when I get to the team scores, these are assigned colors to each juror. So red means something to me. It means that, okay, this juror's not, he's a bad juror. Or, hey, I make him purple. That means that he already said something for cause. I don't need to waste any more time talking to him. Oh, I like him. Okay, great. Undecided. Okay. Or he's a bad juror and I need to go after him and get cause. And so this is a quick way for the lawyer to kind of know where he stands with each juror. If we could, let's go back to the slide deck. All right, so we covered the background colors. And this is important because when you're the lawyer presenting, you can just look at your iPad and know who you need to spend time on and who you can move on with. All right, let's go to the next one. Next slide. So ranking jurors, it's a very subjective thing. And so what I think is nice about this is the lawyer creates their own scales. And if we could, we'll go back to me and I'm going to show how the scales work. So when we're setting the case up, we have these administrative things. And one of the things was color. So we just looked at, and you can rename them and say, hey, this is a nice juror, whatever you want. One of the other things is scales. And in this case, I'm using 3 scales. And you could use 1 scale, 2, you could use none, you can use as many scales as you want. Keep in mind that the way the scales work is that the users are going to each look at these scales and rank the juror. So this one, I've got good juror, bad juror. It's just real vague, open to any kind of interpretation. And so I think Aaron's really a good juror. He seemed very empathetic towards injured people and very open-minded. And so these are all traits that I decided on my scale I wanted to be good traits. And by the way, this is an amplification scale. And I think that because he is a very highly educated person, manages a lot of people, he has high leadership skills. This multiplies these numbers and it changes his score. And so what happens is when I go back to the colors of the scores, he's really bright green because on the scale, and in fact, if we could go back to the slide deck, I think we could show how -10 is bad traits. If no one marks something down or someone doesn't talk much, it's neutral and that's white. And if they have a lot of positive points and maybe amplified, it becomes bright green. And so what this does is it gives you a color scheme where you can compare your jurors visually when you're on the fly, looking at it with like, hey, the darker red they are, the more dangerous they are. Or the lighter green may not be as good as someone who's darker green. If we could go now to the next slide.
Hey, can I interject here?
Yeah.
Well, go ahead and finish this thought, but I wanted to raise an issue where I think that the technology is really helpful.
Sure. I'm pretty much done because the point is as the lawyer, you can switch between the assigned colors or you can switch to the colors that are based on the ranking and the scoring. And the leadership also amplifies or reduces those scores. So let's go to the next slide. And Aaron, what was your question or thought?
So, I mean, I'm just thinking about this from a practical perspective, and most of the time when I'm in cases at this point in my career, I'm first chair, lead counsel. One of the things, though, that you see throughout a lot of the trial guides books on jury selection is that the suggestion will be that you have someone else taking the notes rather than you as the main questioning lawyer, as an example. And one of the problems that you run into is that if your team isn't all equally qualified, you can end up with some really erroneous decision making, because if you don't have weighted scores sort of in regard to the way that you're asking questions, as an example, you could end up with a junior associate who's now taking your notes, coming up with some very skewed decision making in regards to who should be, removed during the peremptories. So that I think that this is the benefit of coming up with a scheme for rating people based upon their answers, and then the whole team is there. So if you've got a trial consultant, you've got a junior associate, you've got yourself that's first chair, then or a paralegal somewhere in the mix there, litigation paralegal. You're sort of you've come up with a scheme for determining what's the value of a certain type of question versus another, and it's consistent, I guess, amongst the group, because you've coded it in that way before the trial starts. I don't know. What are your thoughts on that, Matt?
Yes, I feel your pain, and you're exactly right. And what happens is you can have as many collaborators as you want, and some of your team members are going to have more experience and they're going to be better at making these subtle distinctions than others. And so there's a function in this where each collaborator gets their own color font, and you can tell by the color of the text and the dots that they mark when they rate someone. And then we built in another thing called exclude spotters. And you go through and you look at the list of all your collaborators, and you can turn some of them off, and it reduces their scores. And then it lets you really refine the view or the calculation based upon who you want to look at. That's good.
Right. Yeah, no, I mean, I think that's great. Because yes, if I have a high quality trial consultant, a David Ball or an Eric Oliver or Harry Plotkin or one of these people, I mean, they're going to be able to spot things potentially that the junior associate may not, because they have a much more fine-tuned expertise in this type of thing than even I do.
Yeah, good point. And sometimes the quality of your information is based upon who put it in. And so you can filter out some of your users and see in the long run who your better ones are. And if we could, is that good? We'll just go on a little bit. I'm going to show you one more button. I'll share my screen now. And in this one sample case I'm working on with you guys and sharing. Okay, in this case, I'm the only person who's collaborating, so it's hard to kick people out. But if you hit the exclude spotters, that's how you can filter that out. But let me jump now to the next topic, which is the symbols library. And what we have is libraries of symbols that you can select and import and use when you're getting the jury questionnaires. There's a lot of information, like they've had prior jury service, or they've had claims made against them, or they have law enforcement background, or or when they're talking, they have hardship. And what these symbols are designed to do is to quickly refresh your recollection of certain traits that they may have, so you don't have to dig through the notes. And this is a great mental shortcut to speed up your presentation to the court, to the jurors, to talk about things that you may want to know about. And you can also custom make your own symbols. You can edit them, you can delete them, whatever you want to do. So in this case, I picked out these symbols. And I also keep track of plaintiff's cause and defense cause, because what's interesting sometimes is when it comes time to make cause challenges, if I make a cause challenge and it's denied, I need to know, and I need to remember that if I run out of peremptories, I may say, Your Honor, this one juror that I saw cause on, you denied it, but they're still on the panel. Would you give me one more peremptory? And they may say yes. Or if a defense seeks cause and it's denied, and maybe it's a juror that I don't like either, I certainly want this to remind me, don't waste one of my valuable peremptories, because I think the defense will kick them off. So that's the value of symbols. And you create them the way you want. And as we showed with this one sample juror, there's the symbols, and you can just mark them and keep track of it. And what it does is it puts these little symbols underneath or next to them on the list view and on the C view. They're right there. Good. What is our next slide? Okay, collaboration is really important because, as Aaron said earlier, when you're the lawyer asking questions to the jury, this is my philosophy. If you are holding a pen and you're taking notes while they're talking, that's a huge rapport breaker. And you do need to totally focus all your energy and attention out to the panel. And so you need to have good note takers taking notes in real time. And as they take notes, they're all feeding in to the jurors' one note section. And another thing is, if you ask a raise your hand question, and I'll get to that a little bit later, your spotters mark who raised their hand, and the lawyer can see who raised their hand. And if someone does a tentative hand, we have a half a hand raise. And so you may go back and ask them a question. We also make a log of who raised their hands to various questions. So if you had a real short amount of time and you needed to cover a lot of list things, you could do raise your hand really quickly and cover a lot and get the information down real quickly. The other thing we talk about, rating your team. When your collaborators are rating with the scales, like they don't like a bad juror or good juror, they cannot see each other's scores. So this helps keep them from being influenced by each other. And if we could, let me share my screen again. And what I'm showing you here is how the notes are taken. And the notes literally are the questions that's being asked, and then the answer gets entered. And this is an example of all the notes going. And you can just say here, sample note, you hit enter, and it comes up on the very bottom. That gives you an idea of how and why collaboration is important. If we could, let's go to the next slide. Okay, so your juror sheets, this is a time saver. You know, the clerk hands you the sheets, and what you should do is divide them up amongst your team and say, okay, you do 10, you do 10, you do 10, you do 10. And so simultaneously, all the information is being entered. People are attaching their symbols, and all the information is feeding in real quickly. Next slide. All right, so it's also important that when you're asking questions, that your collaborators, your spotters can see where you are, what question you're asking, and record what question. So if we could, let me share my screen and jump back over here. I'll show you another cool thing. So one of the outlines is you set up, there's the questions you want. You can edit them, change them, create new ones, give them colors, whatever you want. And then when you're ready to present at trial, you hit start questions. And so I can still see the gallery and I can see my questions. And when I tap on one, it puts a box around it. And what that does for everybody is that question is now here in the notes. And so when I add my answer, yes, I know the clerk. That note goes in there. Now the question is in context with the answer. So, and after I ask that question, I double strike it and I go on to the next one, and it allows you to do stuff like that. And if you ask a hand raising question, and what I typically do is I put it in some kind of symbol like that so that my spotters know they engage hand raising. And then if you say, okay, this section in the middle, raise your hand if you've, if you own a bike or whatever it was, has a driver's license. And then they can raise their hand. So full hand raise, half hands raised. There you go. And so what that does is it lets me know, as the lawyer asking question, who raised their hand, who didn't. A half hand raise is always interesting to me because I want to say, well, why'd you raise your hand? And after someone lowers the hands, you could put it down and you go to the next section. I'm going to show you questions done now. So there's another little feature over here called logs, and it keeps track of who raised their hand for each question. All right, if we could, let's go back to the slide deck. Okay, so maintain rapport is so important with the jury because I don't care what style you're using, whether it's David Ball or Jerry Spence method or cause is king. You always want to maintain the best rapport you can. So eye contact, focus on them, having correct pronunciation of the jurors. And the raise your hand questions always gets lawyers messed up because people raise their hand real quick and then they put them down. And then the lawyer's like, did you raise your hand? And so this juror hand raising is one little thing that helps you maintain rapport and move quickly. All right, our next slide, please. So we talked about the color background colors. That helps a lot. The accurate notes make it important for you to say to the court, this is what the juror said in response to this question. And the symbols are also important if you want to remember, oh, who raised their hand because they had medical problems, work problems, travel, whatever it was. Those are good ways to make sure that when you make your cause challenges, you don't forget. And what I typically do is if a juror has cause, we mark it like a purple background. That way, when the court says, do you have anyone else for cause? I look and I make sure that I didn't leave anyone out that had a purple background. Or you could assign it to blue or green or whatever color you want. All right, next slide. All right, so the color backgrounds are really important for cause. And then when it comes to peremptory challenges, it's really, really important to see subtle differences. And if we could, let me share my screen and we'll talk about the distinctions we're able to make based upon the scoring. Seating. So in this juror, Miss Jones has the most negative scores possible, all -10s, and she's a leader. So that gives her a solid red. Now, I put orange so that we would see cause with her. That's fine. Now let's contrast that with Mr. Last. He has all the highest scores and a leader, so he has a solid green background. And you can toggle between the assigned colors that we gave him that all have sort of a code meaning or the rating. So when it comes time to make cause challenges, I'm going to need to show my purples. And so in this one, I'm going to say, Judge, Mr. Gregory, he said something for cause, and the judge says, okay, cause is granted, and he gets an X, and he's out. All right. And then defense's turn, and they say, well, we believe Mr. Last said something for cause, and the judge denies cause. So I'm going to add a symbol called defendant saw cause. That just reminds me later that I'm certainly not going to use a peremptory challenge. Then the defense says, well, I think this lady should go for cause. So it's granted. And let's say Ms. Patel has a hardship, cause is granted. All right. So now we've got 1, 2, 3, 4 cause have been granted. And now it's time to use peremptory challenges. And I think we need to go back to the slide deck for a second. Okay, good. So using your background colors helps you distinguish between maybe two jurors that are next to each other. If we could, let's go to the next slide. Okay, good. Now let me share again, and I'm going to show you how we track the peremptory challenges, and we use the autofill to fill the jury box so we know who really is going to be on our panel. All right, so now I'm looking at the score colors, and I know I don't like her. He's great. Don't know anything about these people. She's not so good. He's bad. These are better. So we're going to use this button here called autofill. And what that's going to do is it's going to fill the jury box and put everyone in the right box where they're supposed to be, skipping the cause challenges. And so the judge says, okay, Mr. Powell, do you want to use any of your peremptories? I say, yes, I want to use my peremptory on first defendant. Oh, I left a number out. Let me go back and fix this. When you're setting up your case, you want to put in your demographics, but most important, each side gets 3 peremptories and 1 alternate. This is how we keep track of it. 3. I go back to Miss Jones and I go, I want to use a peremptory. And it marks her out. I go back to the C view. And there she is. She's marked out. So I hit the autofill again. It puts her back in the gallery and then moves everyone down and brings in the next alternate. So let's say the defense now uses one of their peremptories on Mr. Last. So we use autofill. He goes back and everyone moves up. And this goes on and on. It keeps track of things. And that is a great way to make sure that you are all on the same page. Everyone knows who's in the box, who's next. And if you're going to use a peremptory challenge, you may look at that whole list and say, well, you know what? I'm worried about Mr. Savage, so I'm going to take him out. And so the color scheme helps you keep that kind of organized.
Yeah,
We go
that's
back.
really helpful, Matt. I mean, I think that, otherwise you're looking at notes and you're going, okay, well, that, this person looks not as good. But I mean, here you've got something pretty concrete that's visually obvious, and you can just go, okay, well, this is the person I'm taking off.
Yeah. And I forgot to say it, but you can send messages to each other while this is going on. And if you wanted to, you could send the attorney who's asking a question, questions, a message, say, hey, don't forget to go back to this person or do something. If we could, let's go back to the slide deck.
Well, I mean, like you got a perfect example here, actually. 15 and 16, you're going like, hey,
Yeah.
uh, you know, you're working with somebody else on the case, obviously, and you're saying, hey, are we sure that we want to take 15 instead of 16? Like I got a bad impression of 16. Why are you thinking 15's worse? I mean, one of those things sort of on the fly. Certainly an important decision to make.
Yeah. And it gives you a little bit more evidence than just kind of hunches and guesses. And sometimes, in the fray of war, we confuse two people or what someone said. And this is really, you go back to your basics and say, oh, everyone wrote this note and this is consistent. This is really why we want to get rid of this juror.
Well, I think the other thing too is if you don't have a break, like let's say you're going all morning, because I mean this happens oftentimes in my cases. I'm thankfully lucky enough to be in practice primarily in two states where we don't have limited voir dire in state court cases, and so I might be going along, but the staff, whoever it is, paralegal, litigation paralegal, associate counsel, referring counsel, whoever else it is that's doing, the note taking with me, they may have figured out something else or seen something else with this person that I didn't see. And I mean, like I've had that happen both as first chair and as second chair, where, if I'm working with like, a large national firm and they've got somebody doing first chair and I'm looking, I've had a number of instances where I've seen things that they haven't seen both during jury selection, but also during trial. And like we'll maybe even get done with a day and you're like, hey, I'm thinking this juror is really against us and they're not seeing that at all. So this is, the benefit of having in particular two really well-trained lawyers on the case together, is that you'll pick up things. And so I think that, if I'm sitting there in first chair and I'm actively doing the jury selection and I'm having to choose between 15 and 16, I need to really look and see why is it that somebody else is like valuing those people the way that they are closely.
Yeah, excellent point. Right. We need every little advantage we can get because we've spent so much time and so much money to get here, and it's all on the line. And every little advantage can make a big difference.
Right.
Let's show the slide deck. Let me see where we are. Okay, next slide. Okay, so let's jump to statistics, and I'm going to show you it has a whole statistics page. Let's go to the next slide just so I know where we are. Privacy. Okay, good. Let's go one more slide. I can show all those at once. Okay, good. All right, let me share my screen. We're going to then move on to social media. Everyone wants to know about social media. All right, so I'm going to address what was it? I'm going to address privacy. We have a blank screen button. If someone's walking behind you, you hit that and it just helps hide all your work product. What was the other thing that we're going to talk about? Jessica, what was that slide? The first point and the
Sorry,
third.
social media.
Okay, and what's the first point too? I skipped that one.
Administrator can turn it on or off.
Okay, good. All right. So the administrative controls allow you, in some jurisdictions, you cannot use social media, in some you can. And if you want, the administrator can say, well, I want to know where they live, and I want to know if they're on Facebook. And what that does is it adds these links where you can go and do social media research and save the information. And if there's something there, you can keep track of it. Or the administrator can turn it off completely. And if you're in federal court, then you're not going to violate any rules. I also want to show one other little thing. In different jurisdictions have different things. In Florida, I'm entitled to get the entire jury venire months in advance, and I can literally do research on all the potential jurors weeks before the jury selection. And then when I'm in the courtroom and they hand me the list, I can go through the venire and just import those people. And so this gives me the power in a really serious case to just go in and do deep research of who the prospective jurors might be. And when they're called, then I've got a heads up, leg up on the other cases or the other side. So I share that with you. It's kind of interesting. Some states have different rules and laws about that. Oh, yeah, this is just a different case. All right, we go back to the slide deck. I gotta stop sharing. I'm sorry, I can't see it. Okay, so that was the venire list I was talking about. And what happens is in Florida, I go to the clerk of the court and I say, give me the CSV file of all 2,000 jurors that have been mailed a summons for this week of trial. They give it to me for free and I can download it and start doing research on all these people and really have a good idea. If those jurors are called in that I was able to find something on, hey, I've got 4 hours of research on each juror before I even started. All right, next slide. And that's pretty much it. I covered everything in about 45 minutes. So we have time for questions. And I love this quote from Clarence Darrow. So what questions do we have, or what can we talk about?
All right. So the first question we have, and a couple of people have put into the comments, but what is the software called?
It's called Honey Juror. And it's available on
And
the App Store.
and the follow-up question, someone said, where can they get the software and how much is it, and does it work with Windows laptops?
It is only an Apple application right now. It will work with iPads, MacBooks, MacBook Pros, anyone that has an M1 chip. We may see this develop to be a cloud-based software. Then you could use other like tablets and desktops and laptops. But right now, that's it.
All right. And these questions came in as you were going, so you might have covered some of them, but this question asks, how can you be doing all of this while not making the jury think you're not looking at them or paying attention to what they say?
Great question. And so the secret to this is when I'm picking the jury, all I've got in my hand is this, and all I'm looking at mostly is the seating chart of my questions. And I know that everyone behind me is taking good notes, keeping it organized, maybe sending me a message. So I'm not breaking rapport. I want to do everything in my power to just stay totally focused and being a good listener. And if you are typing and doing things, you're making mistakes. The other thing is technology takes time. So, you need to meet with your team and you need to go over the colors, you need to go over the scales. You need to set this up so that the symbols, everyone knows what they mean and when to use them. And you need to practice this a little bit. And the more you do it, the more comfortable you get with it. So when you walk into court, you should already have your colors, symbols, scales, and outlines and admin all set up. You should have invited your collaborators. And if I could share my screen again, I'll show a couple little things here. So every person, let me use, I keep putting the same one, sorry. You type in this various information. Let's say I was going to invite Aaron. I send him an invite. And once he registers, then he's registered and I can make his color anything that I want. And so what that will do is when people are typing, I can tell who typed what. That's how you maintain security. And so you want to prepare all of this before you walk into the courtroom and make sure that you're not dealing with technology issues in the courtroom. Good question.
All right, the next question is, how long did it take to become proficient at using this program?
That's a good question. I've probably picked 10 juries with it, and the more I use it, the better I get at it. I found that my office staff, if we had one practice and then one trial, they were up to speed really well because it's pretty intuitive, learning how to move things around. What's not intuitive is how do you import your outline? How do you import your symbols? But that is something that you should work on well before the trial. And you should make it custom for your type of case. You know, this will do criminal cases, civil cases, plaintiff defense, whatever it is. If you're doing a products liability case, you know, the issues are going to be different than a drunk driving motor vehicle crash, or maybe it's a brain injury crash or case. You know, so you want to use all the flexibility to make sure that you're honed into the issues that you really need to pick a good jury.
Great. And we have a couple questions on pricing, and some of them also specifically asked, is the pricing per person or can a certain number of people collaborate on one subscription?
Sure. And the price is $3,000 for a year subscription, and that's assigned to one Apple ID. And you can have 10 collaborators all using it without any problem at the same time. So that's how it goes. And it's as many trials as you want. You don't pay per trial or anything like that.
Okay. Is there a place to type in quotes of what a prospective juror said in answer to a question for when you argue a cause challenge to the court?
Yes. In fact, what I do, let me share my screen one more time. Wonderful question. I tell my team, I want you to type literally as close as you can, word for word, what the juror is saying. And that will allow really good notes. For example, if the question was, what are your thoughts about pain and suffering? And that was the question that was pending, that would show up on the screen and they go, I feel that money won't make up for it. Therefore, I home or money images. Okay, and you could put that in quotes if you wanted. You can highlight it. You can do different things to make it show up the way you want it. So I say that it's really more a training thing to say, please type literally as close as you can exactly what they said, rather than your feelings. I tell people that doesn't, I need to quote what you type, so type it accurately.
Yeah. I mean, I don't know that you have this in your state, but it seems that um, sort of depending on what state and what court, county court I'm in for state court cases, the judge can, of course, vary from saying, okay, well, you should do your cause challenges on the spot, and we're going to take somebody out right now. Or they just say, I don't want any challenges of any variety made in front of the jury, and you're going to have to take all these up in chambers with me outside the presence of the jury. I mean, that seems to be the broad range of how you can do that. And so, for those of you, and there's obviously people all over the country on the webinar today, you got to think through that. Obviously your strategy is going to change a little bit in terms of what you have to do, but if you can do them on the spot, I always think that's way better myself. I want to get them out as soon as I can. But obviously what Matt's suggesting here is much more useful if you have to hold off on all those cause challenges until some point later, like once everything's done.
Yeah, we in Florida do all cause in private away from the jury so they don't hear it. And yeah, good question. Did I show you the
Someone,
statistics page?
No, go ahead. I haven't
I
seen
think I
that.
may have forgotten that. I think that was the thing that was on the list that I wanted to show you. Okay. What's kind of cool is you've got your panel there, but you got the statistic button, and this keeps track by race, and then sub by sex, and then total of who's in the gallery, and over here who's in the jury box. So coincidentally, we have everybody who's a Gen X woman and in the jury box. And this also keeps track of the statistics of who's in the box, who's in the panel, and peremptory challenges based upon race. And so if I go back to the seat view and, oops, why is that? Oh, well, there's only one woman. Let's autofill. Let's look at it again now. There we go. A little more information. I don't know why it was like that. This tells us who's in the box. So no one from the silent generation made it. We've got Gen Z, a lot of baby boomers. So that may affect the way we communicate with our jury panel. And this also helps you figure out, and you can look at this while you're going as you're using your peremptory challenges. So you may say, well, maybe I want to use another peremptory challenge and take number 15 out for some reason from a statistical standpoint. Thanks for letting me share that. I'm glad I didn't forget it.
absolutely. Someone asked, is there a spreadsheet view to quickly enter all the jury information at once?
No. Every juror has their own little page and they have to be done individually, but you can have 10 people entering the data all at once.
Great. Someone asked, how can you do 4 hours of research on 2,000 potential jurors?
Well, let's say you're doing a huge tobacco case, right? And you're talking millions and millions of dollars. You get the list and you say to some of your associates or private investigators, I want you to do a deep dive on all these people. And they go and collect the data. They give you folders of information. They organize it the way you want. And then when you walk in to pick that jury and they go, okay, here's your 100 jurors that are out there in the hallway, you just check them off the list, import them, put them in the right seat, and then open them up and see all the research that was collected. In Zillow, they may tell you whether they own a house that's worth $1 million or they're a tenant renting or something. You may see Facebook stuff. The the deep research is a whole nother topic that I admire the people that can do it. I don't ever have the time because I don't really go out and do that kind of deep research in advance for most of my cases. But if I had a real complex med mal case, I probably would.
Person asked, in Oregon, they have a new law that keeps their jurors anonymous, at least in the courtroom. So they only get juror numbers. Some jurisdictions let us see the names associated with juror numbers, some do not. How would that affect you here?
That's great. Instead of using names, you're just going to put a number. And what's cool is all the seats are numbered. And when the jurors move, their number stays with them when they're in the box. So juror that was in the gallery number 5, when they're in the jury box, they're still number 5. And you can say juror number 5, and rather than have to use last names.
This person asked, what's the best way to practice using this app before you get to trial?
Sit down with your team at a table, have everybody's iPads out or their laptops, and then have a couple people pretend to be jurors and just hold different numbers and just take turns and just bounce around and let people get used to it. That is how I found the best way to train them. That works for me.
And kind of a similar question, if you had a trial in 2 weeks, would you try and learn this to use this software with your team in that time frame?
2 weeks is plenty of time. I say 1 week is enough time. I would not want to learn it over a Saturday or a Sunday. That's just too much stress. I also recommend that for some lawyers, holding an iPad and doing all of the presenting may be a little too much. And if you're just, a notes guy, yellow pad with your questions, it's perfectly fine to do that. And just let everyone behind you take the notes. That is a nice transition. And the first trial, have your notes there ready to go, just in case you get messed up or you have some kind of Wi-Fi issue. You got a backup plan, okay?
This person asks, is there any comparable type of software that works with Windows or PCs?
There is some good stuff out there called Momentous Analytics that works in the cloud and on PCs. Doesn't do all the things. It's a little different, and it's just focused for personal injury attorneys and not for defense or criminal.
Right. But you think this app can be applicable to different types of law?
Yeah, the way it's designed is if you can use the software for other types of cases, like a criminal case, and then it changes the parties' names to the government or the state or the Fed. Little subtle things. It's still the same process that you go through in picking a jury, though.
Right. And then this person asked, did you create this app?
Yes, that's a great question. I've picked a lot of juries, well over 100, and I love this old app that was invented that helped me so immensely that when it got washed out and it wasn't supported anymore, I asked someone to make it for me. And so I started building the app and I wrote it all myself just for my own use. And then finally my friends and family said, why don't you put it on the App Store? People would probably like to use this. And so I started sharing with people, and there's a lot of interest. And I certainly want to help, our side, pick better jurors. You spend all that time working on a case, all that money, you spend all that energy of getting your experts there. It's theater. And you start off picking the jury. And if you start off on a bad foot or wobbly, it's hard to make up for that. And so I think if you pick the right jury, you've won the trial before your opening statement.
Yeah, I completely agree. I don't think there's any way to win if you don't have a good jury. And so, I mean, it's probably the area of law, or the area of trial, at least, that I have studied most, just because I think without being able to get the right jurors in, and sometimes, if you get a bad veneer, there's no way you're going to win, no matter what your facts are. That's just it's my 2 cents. And of course, you can always get favorable juries as well, but um, that's a bit more challenging.
I'll share from my experience. When I got, when I'm comfortable and I'm up there and I'm talking to them, I'm just communicating with the jury and I'm having fun. My confidence level is really high and everything's comfortable. And it's just jiving. You're just doing well. And then I sit down and the defense lawyer is flipping over pages and looking at his seating chart and going to his questions and getting notes from his assistant. And the jury gets impatient suddenly with him. The comparison and the contrast really is a stark difference. Even the judge starts getting irritated with the second lawyer who's relying on paper. So it's really a nice way to build good rapport.
Yeah.
Awesome. Well, those are all the questions that we have. I don't know if we want to leave it for another minute to see if we get any other questions, but otherwise, I would say if there's anything else you want to.
I think my favorite part of a trial is picking the jury. It's just the most dynamic, flexible thing. And being a good listener isn't something that's easily taught, but it's something that's easily learned. It's hard to explain that, but you're going to get in your groove um, and if you can pick a jury in a nice way, you're going to build a tribe that's going to back you up and take you all the way through. Another thing I do is after this jury selection is over, I export who my jurors are into an Excel spreadsheet and into a Word document. And I use their questions and dialogue in my opening or in my questioning of witnesses, and then definitely in my closing argument. Like, you may have wondered about that, da, 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 da. And by keeping those notes available for me, it makes my closing arguments a lot stronger. And I can tell that I'm connecting with jurors when they think someone said that. Maybe it wasn't even them, but some juror said it. And it's like you're honoring the jury because your memory of what was said is pretty accurate at the end of the trial. Those are just some of my observations.
So I have a few comments just in regard to the necessity to go to trial, and I'm going to just put in a quick plug here for those of you who dabble in doing trials or don't do too many trials at all, and are here hoping for some additional information or insights into how to do your trials better. There's been sort of an increasing move of the profession, I think. And this is my observation as the owner of Trial Guides. There's been an increasing move in the profession towards a real stratification of settlement lawyer versus trial lawyer, and in England, sort of the solicitor versus barrister type of model. And one of the things that you need to keep in mind if you're, in a largely settlement firm is that they've been keeping track of us for a long time, decades actually, at the insurance companies in terms of who's doing trial, who is not doing trial. And it's becoming more important because the software being used as an example to evaluate your claims is now integrated with some third-party software. One of them is called Premonition that looks at whether we're going to trial or our trial outcomes. And so increasingly, you're going to start seeing your settlement offers be varied much more widely by whether you do or don't go to trial. And so becoming competent or highly competent in going to trial is going to be increasingly important in terms of the settlement offers that your clients are going to receive. And so I just wanted to put in the plug there that I think it's really worthwhile for us to be studying the methods that we can, using new technologies such as Honey Juror to try to help us to win when we go to trial and encourage us to go to trial more, because I think it'll help all of your clients, not just the ones you're trying the cases for, but everybody that you represent. So I just wanted to put in that plug.
Well said. Like everyone has a credit rating, every lawyer has a trial rating, and they keep very accurate track of that. And if you try cases, it just puts you in a different bracket and you're able to settle your cases a little easier for more money. It's my feeling.
No, that's what's bearing out, and we're seeing it in the claim software side as well. All right.
Buddy, I appreciate your time and attention and interest. And if you have more questions, Matt@mattlaw.com. I'll be glad to talk to you and help you out.
Great. There was one last question that we got, which is this, is the software backwards compatible with older iPads?
If you don't, if you got the big wide plug, it won't fit. If you got the small one, it works fine. And you can even download a free copy on your iPhone just to play around with it. The free copy only limits you to 15 jurors, and you can't change the name. And it's just designed to let you get a feel for it. But it's not, you need to get a modern iPad just because it's quicker and it can process the images faster. You know, you got a lot riding on your case, and a good $600 iPad will work better than a 4-year-old one that may be just limping along. Thank you very much. Bye, everyone.